Hello, friends of the ICL blog, and welcome to another book interview. I'm Toerien van Wyk, an assistant editor for the blog. COVID-19 and the various measures implemented to keep people safe from the virus has drastically altered the way we live our lives day to day. The development and rollout of vaccines brought hope that we would soon return to some kind of normal. But access to vaccines is not equal, and a so-called vaccine gap has developed between high and middle to lower income nations. Recently, the World Health Organization reported that while more than 5.7 billion COVID-19 vaccines have been administered, 73% of those were administered in just 10 countries. The prohibitive cost of acquiring or producing vaccines is part of what stands in the way of access in lower income countries. This cost barrier raises questions about whether pharmaceutical companies are obligated to ensure their vaccines are accessible to all who need them. Or, to put it differently, do corporations have an obligation to contribute towards the protection and realization of fundamental rights, like the rights to life and health? And if they do, how do we determine the substantive content of those obligations? These questions are at the heart of a new book by David Bilchitz called Fundamental Rights and the Legal Obligations of Business, published by Cambridge University Press. I'm delighted to be joined today by David, who is, amongst other things, a professor of fundamental rights and constitutional law in the Faculty of Law at the University of Johannesburg, the director of the South African Institute for Advanced Constitutional, Public, Human Rights and International Law, a professor of law at the University of Reading in the UK, and a vice president of the blog's parent organization, the International Association of Constitutional Law. Welcome, David, and congratulations on the publication. Can you tell us a little about why you chose to write this book?
Greetings, Toerien, and thank you so much for interviewing me. It is wonderful to be with you and the viewers of the ICL blog. In terms of why I wrote this book, my first book was about poverty and fundamental rights. And as you in the introduction laid out, when thinking about these issues, you very quickly realize that it's not just about the state. A lot of the focus of fundamental rights discourse has been around state obligations. And that, in effect, is what many of us have tried to do in thinking about, for example, what is the content of the obligations that the state has in relation to socioeconomic rights. But if you just focus on the state, you only focus on part of the picture. Taking your example of vaccine access, if Pfizer prices the drug extremely high, then you can say, well, the state must provide, but then the state has very few resources to provide anything else. And so we have to think about, in the picture of broader realization of fundamental rights, we have to think about both the state and non-state actors. Now, I spoke here about socioeconomic rights, but of course the issue arises as well in the civil and political rights sphere. Today, social media giants like Facebook and others control and have access to much of our data. And these are significant elements of where the world is heading and have the capacity to affect our rights in a significant way. And so this growth of corporations and business and this increasing power mean that it is vital to consider what are their obligations in relation to fundamental rights. They have a significant impact on the rights and the daily experience of individuals across the world. And surprisingly, there has been limited attention, at least in the legal sphere, paid to determining the content of their obligations, the scope of their obligations. There's been quite a lot of discussion about whether they have obligations, but once you accept that point, how do we determine those obligations? And it is in that gap that I have sought to contribute in this book and to create a legal analytical framework for thinking about corporate obligations.
Great, thanks. Perhaps I can start out by asking you a few questions about methodology. As mentioned, there are these two big questions: whether corporations have fundamental rights obligations and how to determine the content. Both of those questions can be answered from either an international or a domestic constitutional law perspective, or a combination of both. And additionally, the questions lend themselves to engagement with various legal disciplines, as well as several academic disciplines outside of law. So how did you determine which perspectives and subject fields were the most appropriate for the book?
Thanks for that question, Toerien. And this is really quite important in actually writing a book. You have to decide on the scope. And actually, one of the things I initially struggled with is this book going to be constitutional law? Is it going to be in international law? Which sphere am I going to deal with? And then thinking about some of the problems like we just discussed, for example, with vaccine access, you start realizing, well, if South Africa imposes an obligation on Pfizer to provide the drugs or reduce the cost of the drugs, and Pfizer is headquartered in another country, United States, for example, how can South Africa's decision really have an effect if one only considers that one particular jurisdiction? And it seems that the nature of business today, the nature of supply chains, the way in which our world is constructed since the advent of globalization, is that it's not possible to confine ourselves to one jurisdiction alone, or even multiple jurisdictions. And so I decided that to address this question properly, I'm going to have to focus on both the constitutional level, both the domestic level, as well as the domain of the international law as well. And of course, this is complicated, and it means that the book is a longer book than a book that would focus only on one jurisdiction. But nevertheless, it seems to me that this was necessary in order to do justice to the question. At the same time, it also makes sense in terms of the notion of fundamental rights itself, because rights are not just rights for one country. They are, in fact, rights which we recognize as being universal today. They're enshrined in international law and in many constitutions. And so there's a continuity in a way between the domestic and the international, and also a mutual influencing of the domestic constitutional law and the international law spheres. And so in a sense, I thought that was a useful engagement between the different realms. And in fact, there's a conceptual continuity as well. Rights are not different, although there may be some differences as well, which we have to be careful about, in that perhaps at the international level, there will be a more abstract capturing of rights to cover the whole world, whereas we may think about more particular conditions and cultural, historical issues when we're thinking about a particular domestic constitutional law domain. So we have to hold these different aspects together. And I decided that I need to engage with both levels and have sought to do that in the book. I also, you asked a question about disciplines. As I've already mentioned, this does straddle the boundary in a way amongst legal disciplines, because we're dealing with harms that an entity that is usually regarded as a kind of private entity creates. And those harms are often dealt with in tort law. The entity itself is essentially regulated in corporate law. Fundamental rights violations are themselves dealt with usually in public law, constitutional law. And then when we move to the international law domain, we face a range of questions both in private and public international law. So one can't have just a very narrow focus. One has to expand the range of one's focus in law and, in fact, beyond law as well, which makes this a very difficult task around issues on capturing the obligations of businesses around fundamental rights. There's, in fact, a rich discussion in philosophical literature and business ethics literature around the obligations of businesses. I wanted to be clear that this is a book that draws on some of that literature, but it is a book in law itself. But I think, in my view, the best legal scholarship doesn't just focus on law alone. It draws in the insights from disciplines like philosophy, and in my case, the question of the corporate agent raises questions of economics, political science, and a range of other disciplines too. And so where appropriate, I try to take account of some of the developments in those literatures too. Although, as I say, I'm only human, so it's not possible to do justice to all these domains. But hopefully, utilizing that broader perspective helps in some ways enrich the legal domain itself.
Right, and you've mentioned that you developed this analytical framework, which can assist courts and legislatures, even corporations themselves, in determining what their obligations are. In doing that, you also use several methods of reasoning to develop the framework. Can you explain more about your approach there as well?
Thank you very much, Toerien. Yes, and this is something I do some thinking in the introduction about, like, what is the methodology of approaching these issues? And I think it's quite important to make it explicit. As I mentioned, I didn't want something that's purely in the abstract philosophical realm, nor did I want something that is too just a concrete analysis of cases. I wanted something in between, an in-between analysis that allows us to create an analytical framework that is useful for a range of cases, that guides decision-making in a range of cases. And of course, it needs to be applied in those cases too, and that's subsequent work that needs to be done in relation to specific rights, but crosses a range of rights. And as I mentioned, it also is a book in law, and we need to think distinctively about what's distinctive about a legal approach. And here I am inspired by the work and influenced by the work of Dworkin, the famous philosopher Ronald Dworkin, who essentially argues that there are two dimensions in some ways one has to take account of in legal reasoning specifically. The one is the dimension of authority, of case law, of precedent, of the legal cases that have been before, and the domain of justice, the domain of values, the domain of the normative, of ensuring justice is done within a specific domain. And ultimately, our goal is to develop, in a way, the best account of law that is possible, or the best approach in a particular case as well, he would say. And so drawing on that, I, on the one hand, want to root myself in some of the legal developments that have taken place. And so I actually, and I know we will probably talk about this in the first part of the book, engage with what is the current state of play around corporate obligations in the world, and what are courts, both at the international level, regional international level, the European Court on Human Rights, and in other jurisdictions, in domestic jurisdictions, what are they themselves doing when they engaging with corporate impacts on rights? And I try and develop a range of models, I call them, that have been developed. And then from that, in a sense, I find that there emerges actually a similarity, interestingly enough, across those jurisdictions. So I would call this a type of inductive approach, looking at what has been done, drawing that out, and then trying to see, is this in fact desirable? And that's what I try and do then, which really is the sort of attempted theoretical contribution, is to systematize the approach, which I call a multifactorial approach, justify it, and show how it can actually operate and become, almost draw out into an attractive analytical framework, what has already been done, and which can provide guidance for the future. So yes, so that's broadly my methodology, and it engages, as I mentioned, both reflecting on existing law and actually drawing that forward, thinking about the normative and how we make what is into the best possible legal framework that can be.
Yeah, thanks. It's always very interesting to learn about the methodological decisions that underpin a work like this. But moving now from talking about methodology to the argument you put forward in the book, what is the book's central claim?
Thanks, Toerien. And ultimately, it is that the obligations of corporations must be determined by an approach that has reference to multiple factors or normative considerations, together with an inquiry or structured process of reasoning that allows us to reach final determinations concerning those obligations. And a kind of linked kind of element is that ultimately there's going to be an inevitable amount of discretion in the judgments that are made in this regard, and that therefore requires us to think very carefully about how we guide that discretion, how we review that discretion, and that ultimately results in concrete proposals for law reform, both in corporate law and in the international law sphere.
Thanks. One of the things you identify in the book as doing quite important work is the nature of the corporation. You note that different understandings about the nature of the corporation will lead to different perspectives on the extent and the content of corporate obligations. What conception of the nature of the corporation do you advocate for in this book, and why?
Yes, Toerien, it's a central question that I start with, really, and about thinking about the corporate agent itself, because one facet of the theoretical framework and the multifactorial approach is going to be that the nature of the agent affects the obligations that it has. So we need to think very carefully about the agent itself. And I don't take an easy approach here. I contrast, in a sense, two extremes. One approach that essentially sees the corporation as just a vehicle to enable individuals to achieve their goals, which ultimately is self-interested profit maximization for themselves. And another kind of extreme, which essentially sees the corporation as having grown vastly in its power and thus becoming akin to governments in a way. It's called a quasi-governmental entity. And I try and take in the book a middle road. It's something I call the socio-liberal conception of the corporation. And I essentially recognize that the corporation itself is formed by lawmakers. It's not something that's a natural entity in somehow that's out there. It is formed by lawmakers for specific purposes. And as a result, in a legitimate exercise of power by lawmakers, they need to do so in the wider public interest. They cannot aim ultimately to benefit individuals specifically. That would be a misuse of their power. Ultimately, their power must be exercised to create an entity that has wider social effects. And in fact, underlying the capitalist view of the corporation is the notion that corporations do themselves create wider social benefits by virtue of their particular structure, their separate legal personality. They insulate individuals, for example, from risk, and therefore allow people to take more risk. And that in fact generates innovations and wider social goods. These are traditional capitalist ideas, but ultimately the corporation there is being seen as a vehicle to enhance the social and to achieve social benefits. At the same time, I don't completely nationalize the corporation, because I recognize that part of the very goal of the corporation is to, in a sense, harness the individual profit-seeking motive for that social purpose in a way. And so the corporation is constructed in a way which enables individuals to achieve their own goals. And ultimately that is meant to have good social effects. So we need to take account of these two dimensions, the social dimension and the individual dimension. And that leads us to it raises some complexities when we in fact are evaluating the obligations of corporations, which I attempt to deal with in the book. But I also believe that we can't simplify in a way that fails to capture the nature of the entity. And this dual perspective best captures the nature of the agent that we have today and how we should think about it.
Right. As you mentioned already, the first part of the book considers some doctrinal models that have been developed by international and domestic courts in response to the reality that corporations have the potential to impact fundamental rights significantly. Which court did you look to and why? And what is the primary takeaway from this part of the book?
Yes, so in this part of the book, I ultimately am attempting to, as I mentioned, adopt this legal method and go through what has been done in relation to corporate impacts on rights. And in fact, there are a number of jurisdictions and international law foci which really, in a sense, deny that corporations have obligations, but they recognize that corporations have impact on rights. So they attempt through what they try and use state-based frameworks to address the corporate impacts on rights. For instance, by saying that the state has the duty to protect individuals against harms by corporations. But what I attempt to show in this part of the book is that those state-based frameworks inevitably have to construct the obligations of corporations or other non-state actors. So they ultimately, even though they try and deny that non-state actors like corporations have obligations, they invariably, in the process of recognizing their impacts, have to take a view about those obligations. And I go one step further. I actually don't just say they have to take a view. I try and analyze their reasoning about those obligations. What are they saying about those obligations? What content do they give to those obligations? And how do they go about that? So I think that's something that actually goes beyond some of the existing literature, which is often focused about the modalities of application, but doesn't go into the substantive content that arises from the obligations that are inevitably imposed. And as I mentioned before, I attempt to show that there's actually a convergence, despite the divergent legal doctrines. In fact, around determining what obligations non-state actors have, we find there's a convergence on a range of factors and a balancing process, right, which we'll come to when discussing the systematized multifactorial approach. Now, you asked me also, which jurisdictions did I use? So on the international level, I focused on the state duty to protect approach, which I call it. And there I looked at the European Court of Human Rights. And in relation to the other models, the indirect application model, I considered Germany and South Africa. In relation to what I call expanding the state model, where the state is essentially expanded to include non-state actors, I looked at the United States, Germany, and South Africa. And in relation to the direct obligations model, which is different to the other models because it recognizes direct obligations, there the developments have often been in global South countries. And so there I looked at South Africa and Colombia. And the point of choice of jurisdiction is not to necessarily be completely comprehensive. It is to look at both global South and global North jurisdictions. So I think that's really important in our comparative practice, but also to look at jurisdictions that in a way are exemplars of these approaches, and to try and draw on the reasoning. Again, I didn't seek in the book to be exhaustive of all the jurisprudence around non-state actors and corporations. Ultimately, I sought to take a number of cases and tease out what is going on in some of these most seminal cases around the obligations of corporations. And so, as I say, drew on jurisdictions that are themselves exemplars of the various approaches, And lastly, I actually engage also with India in the discussion on the positive obligations of corporations, as they have adopted a fascinating legislative model for imposing a percentage of the net profits of the corporation going to social projects. So as I say, I've been eclectic, but trying to draw on those that are quite opposite to my purposes.
Right, yeah. Perhaps we can turn now to that multifactorial approach that you identify in the first part and then develop further in the second part of the book. Can you tell us more about the approach and why it is that you argue it is normatively justifiable?
Thanks very much, Toerien. And the multifactorial approach is, as I said, it's something that emerged from my engagement with the cases. And what I try and do is kind of systematize it. And in a way, to many constitutional lawyers, this will be quite something quite familiar to them with the way in which rights adjudication takes place. And I suppose one of the things I'm doing here is recognizing the applicability of modes of reasoning that apply generally related to the state and fundamental rights to private sector entities as well. Now, a multifactorial approach is an approach where no single criterion is the basis for reaching a legal conclusion. So there's, in other words, no one normative consideration that alone determines the obligations of corporations. Instead, determining their obligations is dependent upon multiple considerations. And what I found is courts identify a range of these elements, and then you need some decision-making process to reach a final conclusion, which is often referred to under the notion of balancing. Now, it might be lovely to create like a simple rule-based approach, but part of the justification for this approach is the recognition, I go into this in chapter 6, that there is normative complexity in this area, that there's no, that the normative considerations don't allow for just identifying one factor that reaches a conclusion, such as the interests of the victim or the rights holder. We have to consider a range of interests, which include, for example, the autonomy of the corporation and its function in society as well. And so once we recognize that, it's not possible to just reduce our reasoning to one particular factor. We have to consider multiple. This approach is also, I think, attractive because it's incrementalist. And at the moment, we're at in a way, the starting blocks of thinking directly about corporate obligations. And it's also, in many ways, context sensitive. And one of the interesting aspects of corporations is that they vary wildly between the sectors they're involved with, the size, etc. And so in some senses, having something that's kind of calibrated to such an entity in a sensitive way that is multifactorial is in fact quite useful. Of course, there are drawbacks, and this is recognized in the literature around aspects of socioeconomic rights and proportionality, that such approaches can lack clarity. They, may weaken rights by reducing rights to just one consideration amongst many. And in this sphere, it also may allow corporations too much wiggle room for inserting their own interests or self-interested dimensions into the corporate, into the determination of rights. So, and the corporate obligations themselves. So what is to be done in this regard? I acknowledge those drawbacks. I argue that we can't avoid, in some senses, the multifactorial nature of the inquiry, that over time, through adjudication, some bright line rules will develop. But what I seek to do is try and mitigate the effects of some of these drawbacks through, on the one hand, identifying the relevant factors. And I don't pretend to identify all the factors, but I try and focus on those which I regard as most salient. I try and understand the grounding of the factors, the normative grounding, and how those condition obligations, and in a sense, try and arrive at some almost like what we can call prima facie principles, such as, the larger the capacity of a corporate entity to harm a right, the more extensive will be its obligations to avoid harming the right. and the weight attached to its need to avoid negative impact. So we kind of get some prima facie principles, and we then develop a clear reasoning process, a balancing process where factors pull in different directions. And I try outline in relation to negative obligations, I argue for the application of the proportionality test in the context of private actors. And I try, in a sense, engage with the complexities of doing so, as well as justifying why it's appropriate. In relation to positive obligations, I argue that the proportionality analysis isn't fully adequate, and try and develop a 7-step test which captures the range of factors necessary to come to a final conclusion about corporate obligations. And then I recognize that there will still be a lot of discretion involved, and this is perhaps the last part of the book, and that's and then we need to consider various aspects of law that can help ensure that that discretion is exercised in a diligent and fair manner, and proper conclusions are reached in that regard. And as I mentioned, over time, once there's a particular constellation of factors, there's more engagement with the multifactorial approach in specific contexts, we will reach some rules about, in a sense, when certain factors are present, this is the outcome that will take place. So that's broadly an overview of the multifactorial approach and some elements of the justification of it. But as I say, there's more detail, of course, to be considered in the book.
Are there institutional implications that arise from the framework, and what are those?
Yes. So, Toerien, the issue that I faced is I was initially thinking I would stop with a consideration of the obligations of corporations and developing an analytical framework around those obligations. But then I realized, like, a clear implication of what I've said is that there's a high level of ineliminable judgment involved and discretion. And this is very dangerous, particularly in the realm of the corporate actor. The approach that I'm laying out is meant to be one that can be applied by directors and decision makers of all kinds within a corporation. It's not only for courts and adjudicators, although it is for them too. If we simply have unguided, it's not supposed to be unguided judgment, but if we simply have judgment, it opens the door in the sphere where corporations are very self-interested to problematic consequences for fundamental rights and to the failures to exercise discretion adequately. And so I consider then, how can we in some senses ensure that the discretion of decision makers is guided in a way that it can be exercised, as I say, in a diligent manner and in a fair manner, and that there's accountability for the exercise of that discretion. And that led me to consider reforms to corporate law itself. And why corporate law? Some people are like, well, why are we engaging with this sphere? But the corporate law really sets out the rules by which this entity is governed, the corporation is governed. And it seems to me those rules need to themselves mandate and be designed in light of trying to ensure that this entity that's created doesn't harm our fundamental rights and is well designed to help contribute to advancing our rights, because it ultimately has a social purpose. And so when thinking about those things, we need to think about who makes the decisions in a corporation. And I argue for a diversity of experience amongst decision makers. What are their duties? And this leads me to argue for a specific fiduciary duty on directors to consider the fundamental rights impacts. And I formulate that in a specific way. We need to think about their accountability. They're not going to take it seriously unless there's accountability. And that requires both reporting as well as liability. And I argue for looking at the existing actions and how they can be strengthened to ensure that directors, for instance, can be personally liable for authorizing serious harms to fundamental rights. And then we also need to ensure that the decisions that are made internally in the corporation can also be reviewed externally. And And that is critical, and there can be a range of options there, from regulators to courts. But one aspect I take aim at is a legal rule called the business judgment rule, which often leads courts to show a high level of deference to the decisions of business directors or other decision makers within the business, and saying that they are best placed to make judgments around business decisions. And I argue that this rule is inappropriate where fundamental rights are concerned, and that courts do need to review such decisions. And ultimately, in that engagement between the decisions and the courts, we will see the development of our understanding of corporate obligations. And as well, there will be more guidance that develops over time in that way. So that's the implications at the national level. And then, of course, as I mentioned, I also had to consider the international level, and what kind of, how that can help provide standards, guidance, help guide the discretion, improve and enhance the thinking around rights within the corporation. And I consider the fact that at the international level, there are a number of softer mechanisms at the moment, which provide a useful role and in some senses often commit companies to certain standards, but they have a number of drawbacks. Apart from being soft, they themselves often don't develop the standards in any way. They rely on what already exists. And so I argue for the development ultimately of new institutional mechanisms at the international level. I'm involved with the discussions around a treaty on business and human rights. I think a treaty committee that is tasked with thinking seriously about the questions of the substantive content of corporate obligations would help provide guidance helpfully across the world. If there were an individual complaint mechanism at the international level where all remedies failed in other domestic jurisdictions, so a kind of individual complaint mechanism as a last resort, that could help provide guidance on the meaning of rights in particular contexts. And so there are the existing institutions like the European Court could improve and enhance their thinking about issues around rights and the obligations they impose. So there are a range of important institutional implications at the international level as well. And as I mentioned, this is necessary in a way to ensure that the multifactorial approach is properly implemented and institutionalized. And so in a way, we move from considering the substance of obligations to considering the processes by which those obligations are determined. And this, in a way, is very much familiar to constitutional lawyers, or even corporate lawyers as well, who also think about those issues. And I think in a way nicely unites a thinking about substance and a consideration of process.
It's rich and interesting, as you say, and there's a lot more in the book. Unfortunately, we don't have a lot of time, so we'll have to wrap it up there. But thank you for this discussion. It's been really lovely. And I thought I might end by asking you what's next for you in terms of academic projects.
Well, thanks, Toerien, for the interview. It's been a delight, and hopefully look forward to engaging with your viewers around the world at some point about the various ideas. In terms of my projects, well, a natural complement to my current book would be to move to thinking about other non-state actors, for example, religious organizations, civil society organizations and their obligations. So that's one possible area where I've thought of continuing this work. And also, as I've mentioned, there is work about concretization in relation to specific rights as well, because this is a theory that is across rights, but it's actually interesting to think about what does this mean in specific context. So I hope to do that as well. But I hope to continue. I'm generally someone who thinks more broadly about fundamental rights. I often like to summarize rights questions as, you know, the core issues being who must do what for whom, right? And that leads us to think about the rights holders, the rights, those who are obligations bearers, and the content of what must be done, and underlying that are the justification. So those are a range of questions which I struggle with. And one thing I want to think about is the other side of the perspective. Who are the rights bearers? I've done some work in the past in relation to the rights of animals, and I'm actually interested as well in thinking a little bit more about if we take the rights of animals seriously, what governance structures do we need to develop in order to address a recognition of their rights? So in a sense, again, drawing on these themes, thinking about substantive questions, but also relating them in some senses to process. So those are some of the ideas, but you know, one thing when one finishes a book is that you just look forward to also doing a range of interesting academic projects. And so I'm looking forward to that going forward. But thank you once again for the interview.
My pleasure. It sounds very interesting. I'm looking forward to reading more of your work. Thank you also to our listeners and viewers for joining us today. If you've enjoyed this discussion and you're interested in getting a hold of fundamental rights and the legal obligations of business, head over to the new titles and discounts section on our website. There you will find important links and information about a discount currently offered by Cambridge University Press. And for more of the same, keep up to date with the blog by following us on Twitter or subscribing to our mailing list. Lastly, if you've recently published a book on constitutional law and you'd like to be featured in a book interview, contact us at iacl.blogeditor@gmail.com.